Ladies and gentlemen, welcome to the Bridgeford live stream on preserving privacy and asset protection in a transparent world. Our speaker for today's presentation is David Warren, co-founder and chairman of the board at Bridgeford Trust Company. An attorney with nearly 25 years of experience practicing law and working in the financial services industry, David serves the trust and wealth management needs of high and ultra-high net worth families across the nation and around the world. David speaks throughout the country and around the world on modern and progressive U.S. trust law, providing audiences with educational insights on developments regarding modern trust law and practical discussion on powerful planning opportunities available to domestic and international advisors. Ladies and gentlemen, David Warren.
Hello everybody, my name is David Warren. I'm chairman of the board of Bridgeford Trust Company and one of the co-founders. And we are very excited today to talk to you about some pretty exciting topics. But this is our first live stream event, which means that all the mistakes I make in the next hour and a half cannot be easily edited. So I look forward to hearing comments about the mistakes I will probably make in the next 90 minutes. It's so great to see so many people signed up from not only across the country, but really around the world. We have so many people here today with us as well in person, and you know, we love to talk about these topics because they're so timely. And you know, as we get started and get into what we believe to be really exciting and big ideas here in modern trust law, I first wish you all a very happy holiday season. Once we're finished today, we're going to celebrate with some of our team members here in Pennsylvania what we're going to call Festivus. And for those of you who are Seinfeld fans, you'll know the reference, and we'll have time to air our grievances later. But for now, we're going to talk on some pretty hot topics. You know, the world and our world and the financial services industry and the planning industry is just changing so quickly. And, you know, in light of massive data leaks, which is what we're going to talk a little bit about, Pandora Papers, of course, we know about the Panama Papers, and really just a heightened concern for security and the security of data across the world and around, and particularly the United States, it's really led to the proliferation of some pretty powerful data protection regimes, reporting regimes, which we'll get into and talk about and explain at least 3 of them, and there may be a few more that are coming down the horizon. And we're going to spend some time on the Corporate Transparency Act, which is pretty red hot right now because it just went live, if you will, and there's some confusion about its implementation. Hopefully we'll clear some of that up today. But it's going to lead into, you know, the idea of, can we still have asset protection and privacy even in this transparent world? And of course, there's good reason for this transparency, which we'll talk about. But the idea is, and the question is really that we're going to answer today in the next 90 minutes is, can we still though, and should we still seek to achieve privacy and asset protection even in light of these modern regimes of information disclosure? We're going to re-examine modern trust law and how it still and continues to be extremely relevant, even in the context of this heightened transparency. We're going to talk about the importance of jurisdiction selection. You know, for those of you who have been with us in Bridgeford for the last 12 years, that's a topic we've been extremely passionate about. Jurisdiction selection matters. It mattered 12 years ago. It matters perhaps now more than ever, given some of the factors I've already mentioned. And in terms of the ability to select the proper jurisdiction, now there's another conversation that's become pretty relevant. And it goes to the idea of, is there a fiduciary duty? And you know, years ago, we talked about this when we first launched Bridgeford, and we were intrigued by certain articles we wrote, and now, or that we read, and now it's a really important question we need to examine together today to make sure that we are understanding not only the importance, but really the peril that we may be in as an industry if we're not looking at proper trust jurisdiction selection. We'll talk about asset protection and privacy and prudent tax planning, and of course, objective comparisons. You know, there's no question, and it's sort of old news at this point, particularly if you look at the dates of these quotes, but the national media, the international media, unequivocally has determined that the U.S. Has really emerged as a tax and secrecy haven. We don't like the word haven, it scares everybody, I understand that, but the reality is, pre-CTA, Corporate Transparency Act, which we'll talk about in a minute, and post, the United States continues to be, in many respects, the safest and most powerful destination for trust planning for purposes of asset protection and privacy, not secrecy, and we're going to make that determination and distinction in a minute. But the reality is these quotes are still real, even in light of some developing reporting regimes. So we all know the reasons why people are coming to the United States. I mean, there's marriage, there's business activity. But what we're going to examine today is not the reasons, but what is driving the decision from a planning perspective, okay? So taxation planning, not tax evasion. That's not what we're talking about today. That's not what Bridgeford talks about. That's not what the advisors that we work with around the country and across the world talk about. We're talking about tax planning. We're going to talk about privacy. We're going to talk a lot about privacy today, and we're not going to talk about it in the context of secrecy. That's different. That's a different concept. It conjures up ideas of Switzerland. Contrary to certain articles that appeared in certain publications, South Dakota has not become the new Switzerland, nor has the United States. Privacy and secrecy is distinguishable, and we're going to get into that. And talk about the idea of asset protection, and is that still available? Is that something that can happen in the United States versus an offshore solution? And really talk about all of this in the context of, is there really a right to privacy? Do we really have a right to asset protection and to do tax planning? And I think the answer unequivocally is absolutely, which brings us to the Pandora Papers. How many here are aware of this explosion of the Pandora Papers that happened 6 or 7 months ago? Yeah, a lot of you. It was pretty salacious, and unlike other massive data leaks around the world, this one in particular really implicated the United States. Publications from all over the world seized on this information, stolen information, I will point out and remind those of you, stolen information that was taken from 1 or 2 primary international trust companies. 11.9 million confidential documents were taken, and the idea and the thought was, and if you read the headlines, it talked about sort of outing all of these wealthy families around the world, and isn't it horrible? Isn't it horrible? These people became public, and they're doing all of these bad things in the Pandora Papers. When in fact, if you read carefully, there is no evidence in the Pandora Papers that there were any criminal activities going on. That happened that probably appeared in the 6th or 7th or 12th paragraph of the stories that was carried by not only U.S. media but media around the world. Why do I point that out? Because the Pandora Papers and the idea of somehow a large family doing prudent tax planning, engaging in proper protection of information, which we'll call privacy, not secrecy, and engaging in proper and legal asset protection somehow became bad actors in the eyes of certain media outlets and really in the eyes of, in some cases, the world. And so those of us at Bridgeford and those of us in the world community who really believe what we're doing is virtuous and people actually do have a right to privacy, asset protection, and the ability to do prudent and legal tax planning, not tax evasion. We're going to keep making that distinction throughout the next 90 minutes. We found this to be somewhat offensive. It was offensive that South Dakota was focused on in such a negative way, when in fact, again, there was no evidence that suggested any of the families whose name appeared in the Pandora Papers did anything wrong or nefarious. And so you'll see we spent a lot of time on this. There's a podcast on YouTube, on our YouTube channel, that talks about this in the context of the rest of the story. You might be thinking, well, why is David spending so much time on this? Because this sets the stage for what has happened worldwide in terms of the outcry, appropriate outcry, for the ability to discover information and the ability to report certain information in the worldwide investment and planning community. So many of us are aware of CRS. It's something now, again, kind of old news, but it's one of the most salacious, if you will, of the reporting regimes, because it became something that many countries, now well over 200 countries, have signed on. And what it essentially does is gathers important information, some would say private information, of families that are doing planning, as I discussed, and it makes, through a reporting system, the information available to other countries. That's essentially what it is, and that's essentially the distinction between FATCA and CRS, because they essentially gather the same information. Why CRS created such a concern versus FATCA is because of this mandatory reporting from country to country. And often around the world, certain families didn't want that information shared, and that became of concern to them for a good reason. FATCA, of course, does not report all over the world like CRS does, but they're remarkably similar in their objective, which is a positive one. It's to protect the industry and is to protect institutions from unwittingly getting involved with nefarious actors. That's a good thing. That's a good thing for South Dakota. That's a good thing for any of us trying to do the best we can for legitimate families. None of us in this industry want to end up on the front page of the New York Times because we accidentally got ourselves involved with a criminal family in some part of the world. So these regimes are actually good. The question we're going to wrestle with, though, is are we going too far? And how do we define privacy, asset protection, and prudent tax planning in this transparent world that we find ourselves in? Which brings me and us to a really important part of this conversation today. How many people are familiar or have heard of or have paid attention to the Corporate Transparency Act? Yeah, it's all over the news right now. It's not only just in the news relative to our industry, which some could say it's myopic, but it's actually been picked up in the mainstream news because it's the U.S.'s attempt, in large part in reaction to things like the Pandora Papers and the Panama Papers and frankly, some international criticism of the United States for not agreeing to participate in CRS, which is something I neglected to mention, but I'm sure so many of you already know. The United States does not and did not subscribe or otherwise sign up to with the CRS regime, which means that the U.S. does not share information. So there clearly was enormous pressure across the world on the United States to either participate in CRS or create a separate reporting system to be able to really protect the industry in much the same way that these other two that we mentioned, and there's some other ones going online. So this is another aspect of an attempt in our industry to determine and to create a transparent world in which we operate, which again is a good thing. It is absolutely an appropriate development. But the question is, how do we operate in it and still serve our clients appropriately? So briefly about the Corporate Transparency Act. Really, it's intended to prevent and combat money laundering. And that's really what all the other regimes do. And so it's very consistent in theme. What's timely about our conversation today is that within September 29th, the final rules were promulgated. And again, you may say, why is that such a big deal? Because this has been talked about for almost 2 years, and there's been tremendous confusion as to how it's implemented, definitions, what exactly has to be reported, which is what we're going to talk a little bit about today. And the thrust of understanding how to operate under the rubric of the Corporate Transparency Act is understanding the definitions. And so the definitions now are much more clear than they were 10 months ago or 12 months ago when we first started talking about this around the country. A reporting company, you can see for yourself on the slide, it's clearly defined: a corporation, limited liability company, or other entity that meets one or both of these prongs, as we used to say in law school, prongs. I'm not sure why we called them that in law school, but if you meet one of these criteria, this is how you have become what is a company that is mandatorily required to report information. And you'll say what information, and we'll get to that in a second. Another important definition of a reporting company is the exceptions. I always chuckle when I was in law school, and really anywhere I've ever been, you have the rule, and then you have so many exceptions that you forget what the rule is. Well, and it's not unlike what we're dealing with here. There are so many exceptions to who and what company actually becomes or is treated as a reporting company. And I don't mean to make light of it because it's important, because if you are a reporting company and you do not report, there's a lot of trouble, and we'll get to that trouble in a second. But here are the exceptions. A Bridgeford Trust Company arguably is not a reporting company because of the exception, but two of the three exceptions. We're in the banking industry, we're regulated, highly regulated by the South Dakota Division of Banking, and we're large enough in that second criteria to actually be exempt as well. The theory there is that companies of our size, or companies like Bridgeford who are heavily regulated, we are already gathering this information. We are already doing our KYC. We are already doing and taking the appropriate and the necessary steps to root out nefarious people and to avoid and not work with families who may have a criminal intent or are using, for example, South Dakota law to hide from the tax man or to hide assets from a legitimate creditor. Those are not the families that we want to work with or the families that you want to work with, I'm sure. And this is what the CTA is designed to ferret out. Another very important definition, as I said, we have what A is a reporting company, and they have to report on certain information, which we'll get to in a minute, but they have to report the information of a beneficial owner. And now we have a clearer definition of what, in fact, is a beneficial owner. You see that 25% ownership interest of an entity. That is very typical, that's standard. You see it really throughout the industry, 25% is some sort of triggering mechanism that presumes that somebody who owns more than 25% of any entity is going to have the ability to have more control. And we're going to talk about that because after we're done understanding who a beneficial owner is, we have to talk about who has substantial control. And the first one, of course, is easy as well, and we're going to define that next. Substantial control. This was an area of confusion in the initial drafting of it, and I'm happy to see that there's more clarity here. You can see for yourself, serving as a senior officer of the reporting company, easy definition to meet, easy definition, it's an easy way to figure that out. Having the authority to appoint, remove, again, easy. All of these really are easy to understand and easy to figure out who has substantial control, because if they have substantial control, then they're a reporting person. I mean, all of these build on each other. Again, not complicated concepts, but ones that we need to understand as we're facing what will go into effect formally January 1st, 2024. January 1st, 2024, there are no excuses. FinCEN, the regulating body that has promulgated this, has made it very clear after that there penalties will apply, and companies better be ready and better be already reporting at that point, and then we'll get to that. But I like this quote, at the end of the day, this, CTA, Corporate Transparency Act, CRS, FATCA, all of these are designed to close loopholes that allow corporate structuring that obscures owners and decision makers, and therefore eliminates or attempts to eliminate nefarious and negative activity. And avoids the ability or the ability for a nefarious family to find their way into South Dakota or Nevada or any other top-tier trust jurisdiction and use the laws to help them break the law. And that's exactly what it is that these regimes are in place. Okay, what is reported? This isn't complicated at all. It's not a surprise at all. Of course, date of birth, name, address. What's interesting about this FinCEN approach, which I like a lot, is for companies that are considered to be reporting entities, there's going to be the ability to tap into a database. You'll have an identifier number, and rather than going through and having to provide duplicative information, you can just put in your identifier, and it's going to make the reporting process a lot easier, which is a great aspect to this. Penalties are real on this, and this is why we're slowing down and taking some time to understand what this is, because if you don't do this correctly and you're a reporting company, it's going to hurt. It's going to hurt the bottom line. And there are, as you see, it can go up to $10,000, $500 a day for non-compliance. And the CTA creates a criminal aspect, a criminal liability aspect. So arguably, there could be criminal charges brought against a company that's been deemed to be a reporting company and fails to report under this, under the CTA. Storage of information is important and I think vital to understand, because I will tell you, since the first announcement of the scary acronym CTA, the questions we've received from families from all over the world was, what's going to happen with this information and who keeps it private? Because, as thankfully those of us who are listening today in the United States don't have to deal with this problem, but for data breaches. But in countries that I won't name, particularly in Latin America, information like this that's gathered by the government sometimes gets sold into the black market. And sometimes this information becomes public, which creates a dangerous situation for international families. And this isn't hyperbole, this is fact. There are situations that create very dangerous conditions for international families, and it's why they're so concerned, which is why we get the question all the time, well, is the CTA, the Corporate Transparency Act, the US's version of CRS, which is called Client Reporting Standard? We know that. And definitively, the answer is kind of. But here's the definitive difference right now. Could change tomorrow, because although they say the final regs have been issued, we never know when this can change. The important question is, where does this information go? And as it says here, it's stored at the Department of the Treasury, and there's a non-public database, and it's only going to be shared with U.S. institutions. U.S. institutions. So I say U.S. institutions for a reason. What's the difference? What's CRS? Mandatory reporting, what? Among countries, right? This is not among countries. This stays in the United States, and to date, there has been no indication that this information is going to be shared with anybody other than United States and United States entities. So what started out as tremendous concern and a worry and whether the CTA was going to make the United States no longer a jurisdiction of choice and no longer a privacy haven and asset protection haven, again, those scary words, the definitive answer and the conclusion that we've come to on multiple panels and presentations and listening to presentations is the answer is no. This is not the U.S. equivalent of CRS, and it does not mandatorily share this information, sensitive and important information, with other countries. So it brings us to the question that we're going to wrestle with and talk through for the rest of our time together. We've identified the idea of we're living in a transparent world now. I've gone through a couple of different regimes that are now online and something that we all have to deal with, and we all will deal with it. And then as we said earlier, then where do we go from there? How do we plan for our clients in light of all this new transparency? And this is where the idea of trust site of selection comes back to the forefront, why it's more important now than probably ever. I had mentioned in the beginning of our time together today that this was a topic that we became very passionate about, and we're even more so now. We know in the United States, there's no question, not only has the United States kind of emerged as the international jurisdiction of choice, but then that isn't the only answer, that isn't the final answer. Then there's another question, which is, well, which state is the state we should be in the United States? We all know, and so many of us on this call and so many of you in the audience know, that there's been a race for many years among certain jurisdictions, and these top 4 and potentially 5 have been in that race to be the top trust jurisdiction. And these are not, this is people, the Trust in the States magazine, as you see the citation, people like Steve Oceans, we'll talk about in a minute, commentators, people from around the world, they have come together and have generally determined what is considered a top tier trust jurisdiction, which is these 3 or 4. I say there's a question around Wyoming, and we'll get to that towards the end because it's very intriguing to me how and even why Wyoming has become talked about in the context of top-tier trust jurisdictions, given the fact that when you go through each of the comparative data points, it doesn't even fall, in some cases, even in the top 10. Maybe that's the power of marketing over substance, but nevertheless, we need to address that. And when we're talking about jurisdiction in the United States, where do we need to be considering? And those are the top 4 for sure. And as we talk about what is a U.S. jurisdiction of choice and how do we make these determinations, it isn't just the opinion of David Warren or Bridgeford or the advisors we rely on. I mean, there's some objective data that we rely on and look at and data points to compare among the states. So again, we talk about the more transparency. We talk about where do you go in the world to operate under these transparency rules. And we decide, well, the United States continues to be in all of this, in all of these changes, the jurisdiction or haven to take your trusts in planning. And now we say, well, what state do we go to? And here are the criteria we look at. Asset protection. Does the state have a domestic asset protection statute? Dynasty trusts, really the beginning of modern trust law in my view. Taxation. Does the state have state taxation or not? And some particular taxation strategies that we'll talk about in a minute. Privacy rules. Huge. We're going to spend some time on privacy. Remember, privacy, not secrecy. We're allowed to protect our data. Certain states honor that and embody that in their regulations. South Dakota is one of them. And this is important to talk about in a world of new transparency rules. These transparency rules don't say we're not allowed to have privacy, do they? They just say we need to report a little more information, but we still have a fundamental right to privacy. Asset protection in the United States is very interesting. You think Cayman Islands, you think the movie The Firm, you think all the aspects and historical ways people were able to obtain asset protection was always offshore. Now it's not anymore. 20, 30 years ago, Delaware and other states like South Dakota followed suit and created a domestic asset protection trust. There's nothing particularly sexy about it other than it's a self-settled trust, meaning the settlor can settle the trust and enjoy aspects of asset protection from creditors as long as the trust is properly maintained and administered properly in the state where it's in the jurisdiction that it's there. So it's not just establishing the trust, but you also need to have a trust company that knows how to administer these trusts properly to protect jurisdiction and the integrity of these trusts, and that's important. Most states in the United States do not have a domestic asset protection trust, sometimes called a DAP. They're not all created equally, and it's very important to understand that. We're going to hear me say multiple times, maybe too many times, and again, since we're live, we can't cut it out too easily, is that the devil here is in the details when we're looking at all of these concepts and all of these issues. And so when you're looking at an asset protection trust, you need to know the differences. And here they are. You know, there's something called fraudulent conveyance, which is a really fancy way to say look back. And there's the devil in the details. You know, some states have 4 years. South Dakota has 2 years. It's important to understand how long those lookbacks are, which is really a lot of words to say that after 2 years, asset protection attaches or vests, and that's half as much in other jurisdictions and a big driver in terms of why people come to South Dakota. I say best of both worlds because we often get caught up in the hyperbole in places like Heckerling, where we'll be in a month. I cannot wait to see all of you, hopefully. But you get in these very heady, how many angels can dance on the head of a pin discussion, and we have this, well, the only way to get true asset protection is to go to Cayman Islands or to go to the Bahamas and to go offshore. Maybe that's true, maybe it isn't. Maybe it doesn't matter, because in South Dakota and other jurisdictions, you can have both and create the structure where you have U.S. trust law that applies right up until there's an actual need for asset protection, and then the trust can be pulled offshore. Happy to talk about that offline and answer questions. So really, as we debate onshore versus offshore, I often say it really doesn't matter. In the same document, you can achieve both. So let's talk about something else, like how else you can use these asset protection trusts. Some people, families love to use these instead of prenups. Very powerful. Most powerful probably when used in conjunction with prenups. And as you can see, they're often preferable because there's no disclosure requirement, and it's a very powerful planning tool, premarital planning tool. Which brings me to a point that I often hear, too, when people say, well, no, you really have to go offshore to have asset protection. I don't believe that anymore. And then they say, yeah, but these asset protection trusts are not going to hold up in court because, well, there's all kinds of nuanced constitutional principles that is going to ultimately make these fail. Hasn't happened. There's not a single case yet that I'm aware of that has pierced an asset protection trust because the statute was invalid. The only asset protection trust, to my knowledge, that have been pierced in the United States is because there was a fraudulent conveyance. It's a different issue. The idea of domestic asset protection itself as a concept and a planning tool still very much exists, and there's a pretty exciting case with an odd name called Cleopatra that came out of the South Dakota Supreme Court that talked about asset protection as a concept. This was not a self-settled trust case, but it was an examination of something called a spendthrift provision, which is the magic provision in these trusts that make them asset protection trusts. And this case is so interesting because it was very clear the South Dakota Supreme Court would not even entertain a judgment being enforced against the South Dakota Trust by a California court. It was a marital dispute, a creditor claim came out of it, they came to South Dakota, and it was not only did they not enforce the California order and pierce the trust, the opinion itself was fairly blistering in terms of South Dakota's independence and how they're allowed to make their own rules and their own laws, and they're going to abide by them. As far as I know, that case was not appealed to the U.S. Supreme Court, and I'm not surprised. So when people say, well, there's no support for this in the United States, these things are going to be pierced easily. Well, there's a case right on point that says not so much, and there are other cases that also hold at lower level courts that these asset protection trusts are not going to be easily pierced, but for fraudulent conveyance. So let's talk some more about secrecy versus privacy, because it's such an important distinction to make. Now, more than ever, we need to understand what we're talking about. And I love this quote that I saw in Forbes where it says, secrecy is meant that no one, not even the government, sees your affairs. But privacy is meant that the public can't see your affairs, but the government can. clearly the days of secrecy are dead, and they should be dead, right? I mean, let's be blunt about that. Those days should be gone. And the idea, because secrecy does breed at least the appearance of nefarious activity, right? I mean, what do you have to hide if you're so secret? What's so secretive? What are you trying to hide? And why is it that you won't tell your government? You know, and again, we're lucky in the United States because of what I mentioned before. For information, generally speaking, despite maybe a hack or a data breach, is pretty sancti-sanct and protected in the United States. But this is what we're talking about. And it gets to the thesis of where we're going from here, continuing on with how we began. Secrecy is not what we're talking about. We're talking about privacy. And that's what's driving so many international families into the United States and, frankly, into South Dakota. Again, devil's in the details. When you're seeking privacy, and when you're looking for asset protection, just coming to the United States isn't enough. We need to look at each of the top tier trust jurisdictions. And here are the data points. You know, there is something called a quiet trust where there's no disclosure requirement. Let's talk about that. As far as I'm aware, and I think I'm right on this, South Dakota is the only state that has a codified provision that gives the trust protector, and we're going to talk about what a trust protector is soon, the power to tell the trustee, in this case Bridgeford, not to divulge information about a trust to a beneficiary. In most states, when a beneficiary turns a certain age, there's a mandatory disclosure, either it's 18 or 21 or 22. And most of the families that we work with around the world, and particularly in the United States too, they don't want that information to go to Johnny who's at Harvard in his second year. Why? Obvious why. I mean, if I'm at Harvard in my second year and I get a statement from JP Morgan saying I'm the beneficiary of a $400 million trust, am I going to go back to my third year at Harvard? Probably not. Am I going to have the same level of intensity in my studies? Probably not. We all know the stories of shirt sleeves and how money over generations can hurt subsequent generations. So this is a very powerful control mechanism around who knows what about the trust, and that is a big driver into South Dakota. Same thing with a court seal. You know, as I used to do some fiduciary litigation, I can tell you in most states, if a trust ends up in court anywhere in the United States, typically all of that information becomes public. It becomes part of the public sphere, as you will, particularly now with digital media and all the hyperlinks. It's very easy to determine who are the beneficiaries of that trust, who's managing the money, who's the trustee, who's the settlor. That's all information that is private, not secret, private, and should be kept private. And states like South Dakota and Delaware have provisions where you can lock down that information from ever hitting the public sphere. Now, what's different about South Dakota is that it's not discretionary, meaning you don't have to beg a judge to make it private or to keep it out of the private sphere. And it's sealed forever as a matter of law. Unlike Delaware and other states that have some sort of provisions in that regard, most states, well, I said already, it's open to the public, but Delaware is a 3-year seal and it's discretionary. So even if you can convince a judge in Delaware to seal the privacy or the private information, after 3 years it becomes public anyway. So again, devil's in the details. We're talking about, again, privacy, not secrecy, which brings us to the importance of KYC, or otherwise know your customer. This isn't a fun process. Companies like Bridgeford and financial institutions like Morgan Stanley, this is a lot of work. And I say that with some humor because nobody loves getting a 25-point request from their new provider to provide information, but it is essential. It's essential because it's our ability to police ourselves in the industry and to make sure that we're gathering information and make sure we're not dealing with nefarious people, to make sure we're not dealing with dirty money, as they say. And clearly there's a need for uniformity in terms of how all of these institutions operate together. And I'm proud to say South Dakota has spent a lot of time making sure all of us in South Dakota are following the same rules, which are very strict. And I think this is the weapon, right, against the nefarious activity. Not only do we have the safeguards of the various reporting regimes that we've talked about, but we also have the ability on the ground level here to protect the integrity of our industry just by simply doing KYC correctly. And you might be thinking, well, that's not a revolutionary statement, David, and it shouldn't be, but it actually is. we have the power to protect our own industry. We just have to follow the rules. And if we follow the rules, and we're able then to do some amazing things for clients, just because we're following the rules correctly. I mentioned South Dakota Division of Banking is taking this extremely seriously, and we're proud of it. You know, we talk about the word haven and how it's scary, but the reason why, in real particularity, the United States has become considered a tax haven is because of the indefinite suspension of a state tax over many generations. Can't do that in other jurisdictions. What's another way of saying that quote? A dynasty trust. What that quote was really describing is something called a dynasty trust, which typically does not exist in most other international jurisdictions. Most international jurisdictions have forced heirship, which is really a fancy way of saying that at some point the tax laws say that a trust has to end. Well, why does the government want the trust to end at some point? Anybody? So they can collect their taxes. That's why. And that was the purpose of it in the United States for many years. Well, it came from England initially, and it was something I had to learn in law school, and I always joke, I never understood in law school. So when South Dakota became the first to abolish it in 1983, I wasn't born yet though, I wish. When it was abolished in 1983, I was pleased because I never understood in the first place. All joking aside, I did understand it, and I understood it to be arcane, and so did most practitioners, and this is why we're so proud that South Dakota was the first to abolish what was called the rule against perpetuities, allowing trusts to live forever. So going back to that quote, the United States has the mechanism for trusts to live forever, which means what? That means the federal government is never going to be able to force the trust to disperse, and therefore have access to taxation of money, of these assets. And that is, in our view, and in my view, the very birth of modern trust law in the United States. That is, and along with some other modern trust law concepts, completely revolutionized what we were doing in the United States. And so now we have this ability, international families have this ability to come to the United States and have a trust literally live forever. The most compelling of planning tools and the most, I think, ringing endorsement of proper trust planning in the right trust jurisdiction. As with asset protection, and as I've been saying all along, these trusts, these jurisdictions are not created equally. So you have to compare. We're going to compare at the end. So stay with us. There's only another 4 or 5 hours. Once I get to the end of that, we're going to get to a comparison chart, and you're going to really love that. Not 4 or 5 hours. But I will tell you though, the idea of a dynasty trust has set the stage for what it is that we do in our industry. And it doesn't stop there. This jurisdiction selection is so important, not only for the ability of a trust to live forever, but also for the ability to avoid state taxation in the near term. So we talk about the idea of undistributed income and how heretofore, a goofy little term in law school I learned, heretofore, or at least up until the Kasner case at the Supreme Court level, it was presumed that states were allowed to tax trust income that was never distributed to anybody. It just stayed in the trust. And then cases started to develop around the country saying, well, no, that's not constitutional. Why would the state of New Jersey or the state of Pennsylvania or North Carolina or California why should they be allowed to take or tax trusts that are income that has never left the trust? Fair question. And these court cases address it. Kasner was a very exciting case. Supreme Court case I mentioned. I'm proud to say Bridgeford was involved with an amicus brief. It went the taxpayer's way. And the bottom line for this conversation is that it made it clear, or at least it gave a lot more clarity in terms of how any state's attempt to tax undistributed income of a trust that's in a properly structured trust, properly cited trust jurisdiction like South Dakota that does not have a state income tax, the idea of any state trying to tax that, which is called a resident trust in the case law, is unconstitutional for 2 reasons. It violates due process, and it violates due process and Commerce Clause, right? I mean, the Commerce Clause is, states are allowed to make their own rules, and that goes all the way back to Constitutional Law 101 that I didn't always enjoy so much, but I'm glad that it went in our favor here. There's something called an incomplete non-grantor trust, a community property trust. These are simple, well, not so simple, but these are compelling planning tools that exist to save on taxation legally, all by simply choosing the correct trust jurisdiction. You know, we use this word compelling all the time, and I've been teased about that over the years, but this is in fact compelling. You can avoid estate income tax forever by using a dynasty trust. You have the ability to avoid through the ING, of course, I mentioned briefly, but that is a mechanism to avoid capital gains tax on low-cost basis stock. We talked about the undistributed income and the ability to avoid taxation there. If you pick the right trust jurisdiction like South Dakota in the insurance space, and we'll talk about that soon, you can avoid or greatly reduce something called a premium tax. The marital property, community property trust, which we didn't hit on too much, it's another compelling planning tool. But how does a family avail themselves of these types of planning tools? By simply choosing the correct trust jurisdiction. That's why trust situs is so important. It's why we became so excited about it 12 years ago. And that's why we continue to be excited about it, because it continues to matter more and more and more every year. And I love this quote. We found this quote 2012. Absolutely, there have been more changes in the last 20 years than has happened in really 2 centuries. And this is where modern trust law becomes so exciting, because now we've talked about privacy, we've talked about asset protection, we've talked about tax planning tools, we've talked about why these new transparency rules really don't get in the way with respect to our ability to plan for families, particularly here in the United States and top-tier trust jurisdictions. Now we talk about what is this idea of modern trust law and why does it matter? Because these modern trust law tools, particularly the directed trust, have absolutely revolutionized the trust industry. And that sounds like a strong statement, but it's absolutely true. When I was in law school, and when I was at Bank of New York Mellon, and before starting Bridgeford, the option was only to have a trust company at a large institution like one of them I've mentioned, and they would also manage the money. Everything was bundled. The writing on this talked about a bundled approach. Asset management, trust services, private banking, all happening under the same roof, which breeds what? Maybe some conflict of interest? Maybe some decisions being made here and there that maybe aren't in the best interest, fiduciary best interest. I'm not casting particular dispersions. I'm saying when all of those functions, which aren't always consistent and objective, are happening under the same roof, under the same brand, there is the possibility for a conflict of interest. Along comes the idea of the modern directed trust structure. This chart nicely outlines it. It takes a lot of words to explain, but really what this does is bifurcates or trifurcates fiduciary roles and has changed, I don't like this phrase, but it works here. It's been a game changer. It's taken what has been bundled before and unbundled it and created a mechanism to deliver tremendous direction and control to families who want the ability to not have to give up control to a big bank trust company who is going to want to manage the money and may be difficult to deal with. Structure is simple. We have the John Doe Trust. We have an administrative trustee, that's Bridgeford. Administrative trustees don't manage money. Administrative trustees take direction, that's why it's called the directed trust, from an investment committee, which is a fiduciary role, very important. The investment committee can be comprised of the actual settler of the trust under South Dakota law. So talk about delivering direction and control. That investment committee tells an administrative trustee who to hire, what to invest in. Not just liquid assets, but it also applies to the management of money, the management of real estate, the management of businesses, the management of artwork. We, as the administrative trustee, takes a direction. Same thing with the distribution committee. Now, of course, the settler or beneficiary really should not and cannot be on that committee, but that's another control mechanism where rather than coming to the trust company and begging for the $35,000 to have a down payment on a house, the direction is given to the trust company to make that money available by a separate, independent, and conflict-free group or individual. And I can't underscore just how much this has revolutionized the industry to the point where the idea of a traditional bundled approach is starting to really break down, and family offices are seeking out the independent trust company solution to bring modern trust law concepts like this. Another control mechanism that we love to talk about is the trust protector. It's been referred to as a super trustee. You saw it back on the chart there, where it works in conjunction and, frankly, at the same level as the trust. In some cases, in fact, in most cases, the trust protector has the ability to be given more power than the actual trustee, which is pretty important because it's the great equalizer. And the key here is to put somebody in that role that the settlor and the family trusts to do and act what's in a way that's consistent with their interests and what's in their best interest and what they want to do with their money, with their estate over multiple generations. The powers are pretty expansive. I mean, we have the ability through the trust protector role, to tell the trust company not to tell anybody about the existence of the trust. Remember I talked about the quiet trust provisions? This is how it's this is how it's engaged. This is the mechanism to engage it. It also can replace a trust company. It has, if given the authority, it can make investment decisions. It can make distribution decisions. The trust protector can actually add beneficiaries. The trust protector can actually reduce beneficiary interest almost down to zero. Very powerful. And the largest of our families that we work with all over the world love this because it gives them the ability to sleep at night, putting somebody in this role that has that kind of power to oversee trust company operations, oversee investment operations, and if something goes wrong, if the wheels fall off the car, trust protector with a stroke of a pen can simply make a change to radically alter how the trust is being administered. So again, we're talking about modern trust law tools that bring everything in the focus, where you have asset protection. I keep saying you have privacy, you have tax planning, you're in the right jurisdiction, and you don't lose control, which is what we're hearing more and more and more from our families around the world and in the United States, where they need trust planning. They want all those four things I keep talking about. They want to operate in a transparent world. They want to make sure they're following all the reporting regimes, but they don't want to give up control, and they don't have to anymore under modern trust law. There's a bit of a lighter version of a trust protector. A non-fiduciary role only exists in South Dakota, called a family advisor. Some families like this because it doesn't have quite as much power. People more readily like to serve in this role because it's not a fiduciary role, which means there's no particular liability ascribed to it. I can tell you when this went online, so to speak, 3 or 4 years ago, it was a very important differentiator in the marketplace, and a lot of families who traditionally went to other jurisdictions came to South Dakota just to be able to have a trust protector named in their document. And again, it's just another mechanism of control. None of these concepts existed when I was in law school. You know, for those of us here today with us live, well, I guess we're all live, but those of you who are watching on your computers and on your devices, we couldn't credibly talk about trusts in the way that we could now. People were afraid of the idea of an irrevocable trust. When I learned about them in law school, I thought, why would anybody do an irrevocable trust? You gave up control, they were expensive, and you literally had to beg the trust company to sometimes even return your phone call. So now the whole world has changed in that respect, and it's exciting, and it's dynamic, and it's something that we're just thrilled to be a part of at Bridgeford, and to be able to bring to our families around the world. Another control mechanism, probably really the final one that it works in total conjunction with everything that we're talking about, is the ability to decant. So I've already explained the directed trust and trust protector and trust advisor and how you have these various people around to control the trust. But what if you have an old trust and it just isn't performing correctly? What if you have an old trust that was created in New Jersey that has one of the highest tax rates in the country? What if you have a trust that's in California, which of course even has higher tax rates and has no asset protection capability, and has no ability to give you any semblance of privacy? All the things we've been talking about. Well, here's the way to breathe new life into these old, non-performing, stale, if you will, trusts that need to be modernized, because there is the ability to modernize them. It's decanting as you would decant a bottle of wine. I don't know if they named it on that way purposely, it's clever enough, but that's exactly what's happening. You're essentially pouring one old, dare I say again, tired trust into a new trust with more modern dispositive provisions that breathe a new life. Reasons to do it, I've already mentioned. You can change jurisdiction. You can add beneficiaries. There's just so much you can do by virtue of decanting. So it gets back to my point a moment ago. In light of the trust protector and directed trust and decanting, is an irrevocable trust even irrevocable anymore? I mean, I just told you, you can pretty significantly change a trust. Well, irrevocable means not changeable, right? So this is where and how, in my opinion, modern trust law has become so exciting and so dynamic for those of us who get the pleasure of talking about this and these concepts and these planning tools with families from all over the world. I mentioned, the devil's in the details. There are several states that have a decanting statute. They're not all the same. We'll talk towards the end when we do the objective comparison of these states. South Dakota has objectively been considered to have the most progressive decanting and permissive decanting statute in the country for 8 or 9 years in a row now by a Nevada attorney, interestingly enough. And so, again, it isn't, starting back at the top, it isn't just coming to the United States. It isn't just, availing yourselves of the power of U.S. trust law. It's figuring out where to be when you are in the United States. And these are the details that we need to focus on. Which takes me to a new topic for Bridgeford, I think, and me and those of us who are examining and these issues and then get excited about the power of what we can do now that we couldn't do, again, when I was in law school. There's a case called the Ferry out of Massachusetts. There's another one that was reminded by my business partner involving an owner of a football team, Kraft rather. And it raises the specter, well, is there a duty to decant? Remember I just explained to you that part of the decanting that makes it so special is the ability to move it to a jurisdiction that is more favorable. This case, in its decision, asked the question, did the duty, or actually said, there is a duty to decant if the trustee deemed decanting to be in the beneficiary's best interest? What would be in the beneficiary's best interest? Lower taxes on the trust assets? Sure. Bringing asset protection to the assets? Yes. Bringing privacy that didn't exist in the jurisdiction it is? Absolutely. So there are at least 3 reasons why we may have to do this, because we have a fiduciary duty as a trustee. Interesting, isn't it? Let's take it a bit further. Uniform Probate Code talks about this idea and points out and discusses, is there a fiduciary duty to create a trust in a more favorable trust jurisdiction or a top-tier trust jurisdiction? Everything I just went through is not the opinion of David Warren or Bridgeford Trust Company. It's well supported. These modern trust laws exist, and these planning opportunities are there and are being used by the wealthiest and most sophisticated families and planners around the world. So if we know they exist, you take everything I've said today as truth, under the Uniform Code here, 7-305, wouldn't it suggest that we have a duty then to take a look at moving a trust or putting a trust in a more favorable trust jurisdiction? How about the restatement of thirds in trust? We spent a lot of time on that when I was in law school, my fiduciary relations class. In administering the trust, trustees' responsibility include following functions, and it raises the question in the comments. Again, you can read them. A location that is reasonably suitable for the purposes of the trust, for sound administration, and the interest of the beneficiaries. There it is again, the interest of the beneficiaries. I ask again, is it the interest of the beneficiaries? Privacy, asset protection, legal tax planning. Oh, and I forgot to mention before, direction and control. We all would agree those are good objectives, right? So if I am a trustee or I'm an attorney in California and I know these provision exists codified in various guidance or materials we go to for guidance, it really raises the question about what are we doing in our industry? We're not at a country club talking about a clever new scheme to hide money from the government. That's not what we're talking about here. We're talking about legal planning techniques that bring asset protection, privacy, appropriate tax planning, direction and control. We know they exist by simply choosing the right trust jurisdiction. At some point, and nobody likes this word, but I have to say it. At some point, when does it become a question of malpractice for an attorney or a planner, a trust company? If my trust company, if the trust company that I'm an owner in is operating in New Jersey, but I know that South Dakota has better trust laws than New Jersey because of the reasons I just told you, wouldn't you all agree with me based on what we just went through that as a trustee, I have a duty to get that trust out of New Jersey, would I not? And if I don't do it, am I subject to some sort of malpractice? It would be called different. In my world, it would be called breach of trust. If I were still practicing law, it would be called malpractice. So we've gotten to a point of going through and talking about all these concepts and then really raising the important question that I will argue will be answered at some point in court. There will be, I believe, they already may be pending. And we're going to see a court case where beneficiaries come together and sue the trustee, or worse, sue the drafting attorney and say, why didn't you tell me about Delaware or South Dakota or Nevada? Why didn't you do that? And you know what? Because you didn't, the trust was just taxed for 16 years in a row because undistributed income was taxed. Or the trust was forced to be distributed because it was an estate that didn't have dynasty trust laws. You can measure those damages, right? Those are real damages, and it's real money damages. So I think as practitioners, we have to keep these ideas in mind, and we have to be clear on what we're talking about. So I'm talking about asset protection, privacy, prudent tax planning, which brings us to a really exciting aspect of what we're doing at Bridgeford and what we see, what I've known about for many, many years. And I wanted to mention it as part of the conversation and remind us of where we are, right? So again, we're talking about operating efficiently from a tax planning, asset protection, privacy, direction and control perspective, using modern trust law. And doing it appropriately under these new transparency regulations. And there's another alternative, and it works very much in conjunction with all the modern trust laws that we talked about. It's called private placement life insurance. It's only available to you have to qualify for this. It's been around, as I mentioned, for many, many, many years. But as of late, it's become, extremely powerful or extremely interesting to people because it really creates a wrapper around all kinds of investments, most kinds of investments. There are some caveats, depending on the state you're in. And it allows for the treatment of assets inside of an insurance wrapper that provides all of the three aspects that we've talked about. You think of it this way. $10 million investment account, Merrill Lynch, Morgan Stanley. And you're looking for tax benefits, private, as I said, asset protection, privacy. You essentially create a private placement life insurance policy and put those assets in it. You can still have those assets managed consistent with investment policy statements as long as there's some arm's length. And you can have not only all of the things I mentioned, but extreme tax efficiency. There's been articles written, in fact, especially at the end of last year, saying that this might be one of the last bastion of really compelling tax planning, given all the different changes in the tax world. So much so that certain senators, one of which kind of went to war with the private placement life insurance industry, claiming somehow that this was, nefarious and tax fraud, and which is not at all supported by any of the facts. There's probably hundreds and hundreds of private level rulings looking at private placement life insurance. But the reality is, it is powerful, and in conjunction with modern trust law and the things that we've talked about, it works. So let's wind down here and talk a bit about the all-important, in my opinion, devil in the details comparison of trust jurisdictions. This is pieces of a chart that is available to you. I know we're going to make that available to you on your screen, the link, to figure out how to really compare this stuff. I told you in the early days of Bridgeford, before even Bridgeford had a name, we became intellectually curious about what is and where should people generally think to be in the United States. Because it just isn't an opinion anymore. There is objective data to compare it. Even when we were deciding where to put our trust company, we took the same intellectual exercise and said, okay, you have 4 top-tier trust jurisdictions where do we think is the best for the type of clients that we're going to work with? And we selected South Dakota, and there are good reasons, and we're going to talk about that. And my point today isn't to convince you all to move to South Dakota or to set up a South Dakota trust. My point is to talk about there are options under modern trust law to work efficiently within the framework of a transparent society in a transparent world. That's the thesis. But we can't have that conversation without carefully looking at a comparison of data points. I used to have Nevada and South Dakota because I think in the literature, the recent literature, 5-6 years, generally speaking, lots of groups, lots of industry publications consider these two to be really the top two trust jurisdictions. We can debate it over a glass of wine later if you'd like to, but generally this is what you see. And so I like to do the quick comparison. Do they both have dynasty trusts? Absolutely. South Dakota was rated #1 by Steve Oceans, who's a Nevada attorney, I point out, for a myriad of reasons. And again, you can see the larger chart. South Dakota has a community property trust. Nevada does not. The canting statute, South Dakota was rated #1 in the country, as I mentioned. Again, these are facts. This isn't marketing. These are facts here. And Steve Oceans, again, the Nevada attorney, said so. Trust privacy provisions, I've already pointed out that South Dakota unequivocally has the most powerful aspect of privacy, more so than Nevada. Special purpose entity, we may get to that at some point later today. Various aspects. One of the data points that we haven't talked about, which is important, especially coming out of COVID, is how healthy is a state right now? So many state governments were placed under tremendous pressure to produce government assistance for families who were suffering through COVID and financially and otherwise. And so a lot of states are under siege that are considered top-tier trust jurisdictions from a economic perspective. And you might be thinking, okay, David, why do I care? You care because if you place your trust in a state, let's say like Alaska, which has always been considered to be pretty solid, as a state, and what if you wake up one day and because Alaska's having so many fiscal problems at the state level, they say, you know what, we're going to have to start taxing trusts. You don't want that to happen, right? So this is part of the decision-making process. You want to pick the right jurisdiction. I mention Alaska because in some charts, it's rated the worst right now in terms of economic stability. You see Nevada here is rated 29 versus South Dakota, which has been rated #1. I love the South Dakota versus Delaware comparison. When I was in law school and when I practiced law, Delaware was the place to be. And I argue that it still is a very good place to be. I think objectively, and even as pointed out by Trust and Estates magazine, Delaware is not quite as progressive as Nevada and South Dakota. I think that's generally understood. Trust and Estates magazine has said now for 2 years in a row, because just about every year they go through a very detailed comparison of top-tier trust jurisdictions, and they've sort of said if Delaware doesn't keep up, it's going to fall out of the top tier. Some of these charts that I've referenced that you'll see as footnotes in the larger chart, and I encourage you to look at it, actually have Delaware going into 8th, 9th, 10th position behind states like Tennessee, Wyoming. I'm not suggesting Delaware's bad. I think Delaware's a fine state. But if there is a better option, why not take the better option? And so that's why these charts are so important and so instructive. Which leads me to the Wyoming question, because I'm coming back to kind of where I began. But because I'm picking on Wyoming, I'm actually very impressed with whatever marketing machine they have in place. We constantly see Wyoming being talked about in the context of trust jurisdiction and in the context of it being a top-tier trust jurisdiction. And man, it's really, I say that not because I'm necessarily competing with Wyoming. I say because it astonishes me when you look at the trust laws of Wyoming compared to South Dakota, Delaware, Alaska, Nevada. It clearly doesn't have, or otherwise rated anywhere near as high as those other jurisdictions. So I wonder what's driving this conversation, and I often get confused, and I actually have become alarmed. And also, if you look at their ranking as fiscal health, they're all the way at 48, which means that even though they might be saying today, again, there may be no state taxation, who knows when they need to find money, where they're going to look for it, and could be out of the trust industry, who knows. So I raise this again as part of our overall theme of understanding the details and making careful decisions. And in the context of Wyoming and what we're seeing proliferate in the trust industry, which to me is alarming, is this idea of an unregulated versus regulated trust company scenario. There, and Wyoming has talked about this, I think Nevada has talked about this, and basically it's this idea that you can have a trust company operate in a jurisdiction in the United States with very little or no regulatory oversight. And somehow we've accepted the hyperbole that that's a good thing. And I'm not sure how, in any universe, that's a good thing to have a trust company who's responsible for billions of dollars or millions of dollars and making proper decisions and asset protection and privacy. And all. How do you know these companies are operating correctly if there's no oversight? We might not like regulation, and we just came through a banking exam, and if any examiners have dialed in, thank you. We had a wonderful time. Can't wait for the next one. But it's a lot of work, and it's a lot. But they're not there to hurt you. They're not there to hurt Bridgeford. They're there to help us. They're there to make sure that we're doing the right thing. They're there to make sure the industry is protected. Regulating and regulations are there to make sure the trusts and their integrities and the integrity of the trusts are protected. Why? Because if the integrity of the trust isn't protected, then all of a sudden, all these great planning tools go away, right? Because then the trust is pierced, because it's not being operated correctly. Trust company doesn't carry enough capital. Whatever the reason, this is why regulation is so important. So I don't know how a family would go through the decision-making tree and say, yeah, it's a good idea to put $1 billion in a trust company that has no regulation whatsoever. Why not? You know, I mean, why would we want anybody to make sure the trust company is operating correctly? I know I sound a little sarcastic, but when I put my lawyer hat back on, to me that's a hard thing to consider and a hard thing to understand, and something that we need to talk about. As we, again, kind of wind down and get to questions, one of the other things we're seeing in the industry, which is very sort of intriguing to me, as well as everything else, is, what did I say at the beginning? I said the United States has become the jurisdiction of choice. It's a haven, it's a tax haven, it's a privacy haven. Said it a couple times. Went through for over an hour now why it still is in light of all these transparency rules. So because of that, you have international trust companies who operate all over the world. Guess what they're doing? Coming into the United States to get U.S. trust powers. They're coming particularly into South Dakota to get trust powers because it's a great business decision. I mean, if the world's coming to the United States, why wouldn't you put your trust company there, right? It's a great revenue grab. I'm a business owner. I would probably do the same thing if I were operating trust companies in Jersey or Guernsey or Bahamas or whatever. And I welcome it, only to the extent that they're operating correctly. And that's where we're running into international-based trust companies coming in who don't understand U.S. trust law, have a hard time finding talent, and are, in my opinion, where the weakness is in the U.S. trust industry. Now, I'm not being negative, and I'm not going to name any names, but I'm certainly going to say that if there's a black mark that ever hits our trust industry, or if the industry ever receives a black eye on the front page of the New York Times, it's going to be because of an international trust company who's not familiar with the proper way to handle U.S. trust law and U.S. trust administration. So while I applaud the business acumen, I question the legitimacy, or I should say not the legitimacy, I question the efficiency and the knowledge base of how these trust companies operate in the United States. And trust companies like ours, like a myriad of others who have been doing this from the beginning in South Dakota, in Nevada, in Wyoming, if that's your choice, we have always been U.S. based. And we, because of changes around the world, have become at the forefront of offering sophisticated planning opportunities to families all over the world. And as we said at the beginning, there's a reason for that. So as we conclude and we get to questions, because I think we have some, I want to quickly sort of recap, because it's important. There's a very deliberate and thoughtful theme here. In the world of transparency, which is only going to become more compelling, we need to remember that sort of all is not lost, so to speak. We still have planning tools for our families. I think that even coming out of the Pandora Papers, I think we still need to believe in the integrity of the business. I don't think we should be ashamed of the work that we do. I think people are entitled to asset protection and privacy, as we talked about. I think that as long as we're following the rules, and we are, by and large. I think that there are outliers, but by and large, we are following the rules very carefully. We should celebrate what we're doing for families. We should not feel bad about the work we're doing for families because of bad media and inappropriate and probably outright misleading reporting in certain circumstances, particularly around the Pandora Papers. So I love this conversation. I'm looking forward to the questions. I look forward to the opportunity to certainly work with families going forward. As I'm sure is evident, we have an extreme passion and enthusiasm about bringing what we believe to be some of the most powerful trust planning law strategies to families from all over the world. And with that, I think we'll take a short break and then put the questions together and come back for another couple of hours together. We are happy to be back at a really great almost hour and a half together, and we have some really wonderful questions. One that's not on here, but just came in right before we came back, is the question about Florida law from our friend Jose, which is a really great question. For those of you who are in Florida, and I suspect there's a lot of you and people who've been paying attention to the industry, Florida is definitely making great strides to become a top-tier trust jurisdiction among the likes of South Dakota, Nevada, Delaware. And what they've recently enacted was a directed trust statute. And as you talked about, we're real excited about that. And I think it's a lot like South Dakota's. So kudos to Florida for sure. They don't have state income tax, and they don't have, well, that's a big proponent of it. What Florida does not have, and Jose, it's a great question, but not a bad jurisdiction, but what they don't have yet is a self-settled directed asset, or a self-settled asset protection trust, which is a big reason why Florida families typically go to a jurisdiction like South Dakota or Nevada. I talked about some of the privacy provisions as well, which Florida has yet to enact. And some of the other control mechanisms, I know the trust protector provision, while they have one, isn't quite as expansive as other jurisdictions. But again, Jose, not to say that Florida is a bad jurisdiction, and I can tell you that if a family ultimately decided, particularly one that is in Florida, went to Florida or stays in Florida, I can't say it's necessarily a bad decision, and that's a great question. I expect Florida to continue, in fact, to kind of ascend up the proverbial rankings because they're doing the best they can. And I applaud any state that would do that. I wonder why the state I'm in at the moment, Pennsylvania or Florida for sure, California or others, why other states don't actually jump into this game and become more progressive. I mean, why lose that revenue? I guess it's easier just to complain about South Dakota and Nevada and Delaware rather than to improve your own trust laws. I'm going to go through these questions somewhat quickly, but they're great questions. Somebody had asked about some lawyers using something called a special purpose entity, and I applaud you for knowing what that is. A lot of folks don't, and how that works in conjunction with a directed trust. So we talked about how a settler or really anybody can serve as a trust protector, investment advisor, or distribution advisor. And where special purpose entities are so important and really useful is in the idea of making sure we're disrupting nexus with home state. So let's use California for example. What we want to avoid is placing any California resident in a fiduciary role like any one of the three that I had mentioned. And this idea of a special purpose entity, which really only exists in South Dakota, at least codified to my knowledge, is a South Dakota entity, special purpose, only for the purpose of serving in one of those three roles. And it is a way to remove jurisdiction or any nexus jurisdiction connection with a state like California, which is really another way of saying, or allowing, I should say, somebody in New Jersey for a New Jersey settler or California or Pennsylvania to serve in that control mechanism and avoid potentially triggering nexus with home state. Now, I should give a caveat on that. There is no case law on that, and there's no, this is how we've been operating and using the special purpose entity, but it has not yet been tested, primarily because it's pretty clear, I think, that it does disrupt nexus, and if there was a question on it, it would have gone to court. So it's not a legal opinion, that's just my observation. I think it's a pretty clear planning technique. Yeah, it's a wonderful question. Why was South Dakota singled out in the Pandora Papers? And I could tell you those of us who own South Dakota trust companies had that same question. I think primarily, though, is because the main trust company, international trust company I'll mention, and I won't mention their name, that was hacked, had a large presence in South Dakota, and There seemed to be a presumption that a lot of those trusts resided in South Dakota, so that's what made the headline. What didn't make the headline, as I pointed out, is that none of those South Dakota trusts that were identified were found to have been engaged in any sort of criminal activity. So I think the answer to the question is it just happened to be the trust company that was breached, and it happened to have a lot of South Dakota trusts. And of course, I think it was irresponsible reporting to somehow suggest that South Dakota was this jurisdiction to do bad things or to hide dirty money or to work with bad actors. It wasn't the case, and I think the media representation of that was awful. I mentioned quickly the community property trust, and I appreciate this question. And it is in the context of choosing correct trust jurisdiction. There's only 3 states that I'm aware of as I stand here today that have a community property trust. And a community property trust is a way to take property and treat it as community property, even for residents that are in a state that does not have community property trust laws. So here's the example. Husband and wife in California, well, California's community property trust. So husband and wife in a non-community property state have $100 million of liquid assets. And it has very low cost basis. They've been investing this money for 55 years of their existence together, 60 years, and they amassed this fortune with very low cost basis. The idea is a properly constructed community property trust in a state like South Dakota. At the first to die of the spouse, there's a 100% step up in basis, meaning that we've saved a lot of money in capital gains. That's another way of saying that. And so used in conjunction with the dynasty trust and the Ing strategies and the other things that we've talked about, very, 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 again, there's that word, compelling, but it works. And I know that has been looked at by the IRS in conjunction with various other private letter rulings, and it hasn't been challenged. And it's really a planning tool that I don't think we talk about enough, and I'm glad you asked that question, and I should spend more time on that. Question about decant, and the question reads, is there a notice requirement to beneficiaries of the intent to decant a trust? And that's a really important question, because often when there's a decant, it involves a disgruntled beneficiary, or it involves a complicated family situation. And often we're asked, or the question is asked, well, do we have to tell the beneficiaries, or really anybody, that we're decanting the trust? And remember what decanting is. We're taking a trust here and pouring it into a trust in South Dakota. Trust could also still be in South Dakota in its initial phase. The point is, it is a material change, and it usually is a material jurisdiction change. And so under South Dakota law, to answer that question specifically, there is no notice requirement under South Dakota law, none. So legally, the answer is no. From a business decision, each trust company has to make that decision on its own, because the moving party, if you will, or the person or entity that initiates the decant or makes distribution of trust assets from one trust to new trust is the trust company. It's a distribution. We like it to be directed at Bridgeford, but we can do it on our own motion at our own discretion. So while the law says that there's no notice requirement, the question is, are we setting Bridgeford up for some, or is the trust company, let's say, setting itself up for some sort of lawsuit or public conflict? And so that's a business decision. And there are times when Bridgeford has decided not to give notice because we don't have to. Other times we think the situation is so contentious that we better give notice because we know a lawsuit's coming, so they better know about it. And why giving notice is advantageous is because you told them about it. And they have a 90-day or 60-day, 30-day period to run the court to complain and try to stop it. And then if they don't, then we proceed. So we would rather that, at the end of the day, that kind of assurance from the court, rather than roll the dice and not give notice and suddenly find ourselves in court. And that's I was going to say the short answer, but that's not really a short answer. I guess the last question we'll consider here, is the trustee required to report under the CTA, Corporate Transparency Act, information about beneficial owners of entities held in trust? And that is, almost $1 million question, and something I've talked to Terry Prendergast, our external South Dakota counsel, at length about, and our internal general counsel, Ashley Blake, and others, and debated this. Here's the example. Companies like Bridgeford, working with families from all over the world, will own entities that fit the definitional requirements that I went through earlier in the presentation. So Bridgeford owns, well, I should be very clear. Bridgeford at the top, Trust, John Doe Trust owns ABC LLC. That's the entity. That's the reporting entity under the CTA. The question that's being asked is, well, does the trustee of the trust that owns the entity, the ABC LLC, have the requirement to report? And it's an important question, because for those of us in the business, that could be an expensive answer. If the answer is yes, then we have to figure out a way how to report on literally thousands of entities that Bridgeford Trusts own, that Bridgeford Trust administers at the trust level. And the answer seems to be no. The trust itself does not have the obligation. It's the underlying entity. The real question from a business decision perspective is, should the trust company, on behalf of as the trustee, do it anyway and just gather the information and report it and figure out ways to do it and just charge a little more, but to make sure these entities are compliant? Other solutions have been to have very strict disclosures yearly from the entity owners at the trust that the trust owns, to make sure that they are compliant. So that's a really good question, and it gets to the point that there still is a fair amount of confusion around the CTA, if we're being honest. There's still some questions about its implementation and certain mechanical aspects of it. So more to come. We have a hell of a lot more clarity than we did a year ago, but not quite crystal clear clarity at the moment, and we're looking forward to that. So I think those are the questions that we're going to address here. I have to say it's been a great almost 90 minutes together. As I said before the break and before we forgot to shut my mic off, we are very excited about the concepts that we talk about. And it's exciting for us because we've been talking about these concepts now for over 12 years, writing about them. You can see them on our website. You can see them on our blog. You can see them and hear them talked about on our podcast series, which we're wildly excited about, and the myriad of events that we've spoken at and webinars. So please go to the website, take a look. This is, for us, it's about education. It's about being of use in our community. We're very proud of what we do for our families, and we're proud to be able to continue to do it, even in light of the enhanced transparency rules. And we'll end as we begin, and we will end as we began. Even in light of a more transparent world, we have tremendous opportunity to do amazing planning for our families around asset protection, privacy, and all the things we talked about today using U.S. modern trust law. So thank you all so much for tuned in. Thank you for showing up today. Wish you all a very, very happy holiday season, and hopefully we'll see you at a STEP event or a Heckerling coming up in a month or so. It's a pleasure to serve the community and to be of use, and we hope to see you soon.